everyone. Thanks for joining us today. As Stephanie said, there aren't going to be any slides, but I do want to give the brief overview that we usually give about the center and the work that we do. So we are the Public Health Law Center, which is located in St. Paul, Minnesota, and our offices are located in the Bedote region, which is the birthplace and center of all things for the Dakota people. We provide what's called legal technical assistance, which means we do research, policy development, resources and trainings and webinars like this, but we don't provide any direct representation and we don't lobby. It's also worth noting that all of the work that we do is done in consideration of advancing equity. What that means is that we are focused on partnering with communities and organizations to use the power of law and policy in a way that addresses the social determinants of health and meets the specific needs of all communities, especially those who unfairly bear a greater burden of public health and other societal harms. And in continuance of that work and focus on that work, we also like to acknowledge that when we talk about commercial tobacco, we're making an intentional distinction between the harmful use of commercial tobacco and the sacred and traditional use of tobacco by Indigenous communities. So, to start us off, I am going to start with a brief introduction, and then we will get into talking about a little bit of the history, talking about the FDA's recent announcement, and then we'll talk about what comes next. So in 2012, the Tobacco Products Scientific Advisory Committee, or TPSAC, released their comprehensive report on the public health impact of continued inaction in removing menthol cigarettes from the market. They estimated that by 2020, menthol would account for 17,000 premature deaths and 2.3 million people initiating smoking. Even more concerning, they estimated that 4,716 of those 17,000 premature deaths would be African Americans, reflecting the disproportionate health burden of menthol in this community. And while most of the current modeling data demonstrates these disparities for African Americans, research shows that other communities are also susceptible to a high prevalence of menthol use, such as the LGBTQ+ community, Native Hawaiians, and those who identify as Latina, Latino, or Hispanic. And it's also worth noting that this higher menthol use is a direct result of the shameful industry targeting tactics. It's even more disheartening to consider that with the intersection of death and disease between systemic racism, smoking, and COVID-19, it's likely that the true figures were much higher. What was clear 11 years ago and continues to be confirmed through more research is there exists overwhelming evidence that menthol facilitates initiation, creates a deeper addiction, and makes trying to quit harder, and that menthol is a primary driver of health inequity. Today, we are going to talk through all of that, all of the history and the ongoing fight to eliminate menthol. So I will turn it over to Desmond.
Thanks, Natalie. So I'll be talking about how we got to where we are today. And it's been a long journey and I've been around for a lot of it. As Natalie said, things start well before the Tobacco Control Act with industry targeting of particular communities with menthol cigarettes. And the Tobacco Control Act was passed in 2009. It prohibits flavors in cigarettes except for menthol. So it was an exemption that was written into the statute that enables the FDA to regulate tobacco products. Also, as Natalie mentioned, one of the first things that the FDA had to do once it started regulating cigarettes was to commission its advisory committee. So that's a panel of outside experts to study menthol and look at the impact on public health. And that report was handed into the FDA and finalized in 2012. So there were a few of us doing federal work back then, and a lot of people thought that the FDA was going to act on that evidence right away. Like that was going to be thing number one right out the door after, the graphic warning rule and some of the other things that were required of the FDA in the early days. And that didn't happen. And so we took steps that we thought would sort of be a backstop to that, which is to file what's called a citizen petition. So when you hear the word petition, you're probably picturing teenagers on a street corner with a clipboard trying to get you to save the whales. And this is a very, very different thing. So this is actually a legal mechanism that's built into federal statute. You can actually petition any executive branch agency to take particular actions. In the case of the FDA, you can petition the agency to promulgate a new rule, to amend a rule, or to revoke a rule. And when you petition the agency, it looks more like sort of a legal complaint. Here's all the reasons you should take this action, and here's the discrete action that you should take. And our petition compiled all the evidence that was out at the time, including the TPSAC report, hundreds of studies on menthol over the years, and asked the FDA to remove the exemption for menthol, which it had the authority to do. So that was filed in 2013. And the other good thing about a petition is that the agency is actually required to respond. So they're required to either accept the petition, deny the petition, or give you what's called a tentative response, which is, we're thinking about it, but we haven't come to the final decision. So that was 2013. And then there were a few times in the past where it sort of looked like the FDA was poised to act. There was what's called an advance notice of proposed rulemaking. I didn't actually write the date on it. I believe it's 2014 or 15 was the first one, where rather than actually putting a proposal on the table, the agency collects information on a particular topic. And then, of course, there was another one after the FDA's 2017 announcement of a new regulatory plan where the FDA was going to address nicotine in cigarettes and flavors in products. And so there was another ANPRM that was relevant to menthol. So the FDA's collected information, but never actually put out a proposal. Well, some of the other folks who co-signed our petition ran out of patience with the FDA, understandably. And so they filed a lawsuit because the FDA had not actually responded to the petition. And so that lawsuit has a few causes of action, but one of them is that the FDA was required to act on the citizen petition requesting a prohibition on menthol, but that action hadn't come. We had received a tentative response, but no final determination in over 7 years. And so, surprising to us, in the course of the litigation, the attorneys for the Department of Justice said that the FDA did in fact intend to respond to the petition in late January. And we were thrilled to hear that, obviously, as everyone was. And so we did one more thing worth mentioning, and that was to supplement our petition. So we were concerned that the action on the petition might have been a denial, the FDA saying that it was not going to act on menthol. And so when you have filed a petition and you put the evidence into a regulatory docket, you can challenge a denial of the petition as something that's arbitrary and capricious or not in accordance with the law. And so the more evidence that's in that docket, the harder it would be for the FDA to argue that its decision was the right outcome. And so we filed a supplement that attempted to compile all of the scientific evidence since the petition was filed in 2013. And so that was filed in mid-January. And actually there was enough information that the Department of Justice went back to the court and said, we need more time. So we're going to give you the decision on April 29th. And so that brings us to last week at this point. And Mike is going to take it from here to talk about what it is that the FDA said they would do and what the announcement came with that.
Thank you, Desmond. So two things happened on the 29th. First, the FDA granted our citizen petition that, again, was filed in 2013. And on that same day, the FDA, on its own motion, issued a press release which expanded the menthol ban to include all flavored cigars, which includes little cigars and cigarillos. And in that press release, it said that this is what is appropriate for the protection of public health. So during my segment here, I'll address the contents of the response and the press release separately. And I'll end by discussing issues around enforcement of the ban. A lot of this might sound as inside baseball, as it were, but bear with me. First, I think it's important to stress that the FDA's response was because of litigation by groups like the African American Tobacco Council, the Center for Black Health Equity, and other public health groups. If it were not for the litigation, it's doubtful that the FDA would have acted when it did and how it did. Be that as it may, one of the things that the FDA does is, in the response, is quietly try to explain the reasons for the delay, for the 8 years delay. In its attempt, it basically throws TPSAC, which is its own scientific advisory board, under the bus. First, the FDA says, although TPSAC had advised it back in 2011 that a menthol ban was appropriate for the protection of public health, which is the legal standard, the FDA says that TPSAC did not tell it how to achieve the ban. Second, the FDA says that TPSAC failed to analyze the issue of the creation of a possible black market for menthol cigarettes in the event of a ban. So the FDA says it had to engage in new research into the issue of contraband. Finally, the FDA claims that it was hamstrung by litigation from tobacco industry, asserting that TPSAC members were improperly appointed. That issue was resolved in the FDA's favor by the appeals court, by the DC Circuit in 2016. Nevertheless, it sounds like the FDA doth protest too much. Also in other areas. In its response, it highlights the work it has been doing since the petition and before. For instance, it says it had issued 2 ANPRMs, what Desmond earlier discussed as the advanced notice of proposed rulemaking in 2014, and that was for menthol cigarettes, and in 2018 for flavors and tobacco products. Second, it says it has also done research into illicit trade and has issued a white paper which concluded that there was low probability of a black market in the event of a ban. Finally, it says it's been engaged internally within the FDA and externally in doing lots and lots of research on the issue of menthol. But in any case, the upshot is that the FDA intends to begin a rulemaking process to prohibit menthol cigarettes. So there's more work ahead. But the FDA's proffered reasoning is worth taking a look at. First, the decision considers a population that used menthol and finds that out of the nearly 19 million current smokers of menthol, nearly 86% are African American versus 30% whites and 50% Hispanics. It also finds that menthol smokers tend to also be gender and sexual minorities. And finally, that menthol smokers tend to be low income. Second, the response examines the effect of menthol on initiation and makes the following finding. It says that the FDA finds that menthol makes it easy to begin smoking because it masks the harshness and irritation of tobacco smoke among new smokers. Second, the response examines the effect menthol has on addiction and similarly finds that menthol, quote, facilitates continued smoking and menthol makes it harder to quit. This is particularly so among African-American menthol smokers who disproportionately have a harder time quitting than non-menthol smokers. Then the FDA concludes that the continued marketing of menthol cigarettes raises profound health equity issues. It finds that this is true for active smokers and non-smokers alike. And finally, the FDA utters these 12 words, quote, FDA believes eliminating menthol as a characterizing flavor in cigarettes would benefit public health. Last, the FDA commits itself to work with, quote, appropriate entities and agencies to provide support to smokers of menthol cigarettes who will quit as a result of the requested prohibition in cigarettes. Now I'll briefly address the FDA's press release. That press release is notable for the following two things. Number one, the document goes further than the response to our citizen petition and extends the proposed menthol ban to cigars, cigarillos, because they are combustible products like tobacco, they look like tobacco, and also pose many of the same health problems that cigarettes do. And like menthol, cigarettes are disproportionately popular among youth and other minority population that we discussed earlier. This is notable because this is a step taken by the FDA without being asked to, showing that it can act if it had the will to act. Another notable item in the press release is a quote from Mitch Zeller, who's the director of the FDA Center for Tobacco Products. It states, "For far too long, certain populations, including African Americans, have been targeted and disproportionately impacted by tobacco use. Despite the tremendous progress we've made in getting people to stop smoking over the last 55 years, that progress has not been experienced by everyone equally. These new flavor standards would reduce cigarette and cigar initiation and use, reduce health disparities, promote health equity by addressing a significant and desperate source of harm." In other words, the FDA is signaling that meeting the tobacco control's legal standard of what is appropriate for the protection of public health include action that will reduce health disparities and promote health equity. This is, to quote former president, huge. Now I'll end by addressing enforcement. As you may know, some of you have heard on social media and on the news, this decision by the FDA has had its detractors, notably groups such as the AATCLC and the National Newspaper Publishers Association. Their stated concern is that the menthol ban gives police another reason to contextually stop, harass, detain individuals whom they suspect are smoking menthol cigarettes. And that those contacts will in turn turn deadly. Now, what we like to say about this is, first, this is pure misinformation that's intended to damage the community support for a great policy that will save and improve lives by exploiting the traumatic and distressing issue of police brutality and systemic racism. Second, we have to consider the source of this misinformation. A lot of this concern is based on industry-funded research. Finally, we are committed to working with partners of good faith in drafting laws and policies to mitigate any collateral consequences of the menthol bans should they occur. With that, I'll turn this over to my colleague, Kyra Hill, who will speak on what comes next. Thank you.
Thank you, Mike. Great. So now that we know what the FDA's plan is, how is it going to unfold? What's the timing? How do we participate as members of the public? I'm going to answer those questions, and then after that, we'll get to the questions that all of you are asking in the chat and the Q&A, which are great. So as Mike was talking about the FDA's press release, in that press release, the FDA indicated that it plans to release a proposed rule within the next year. Also on April 29th last week, the acting commissioner of the FDA, Janet Woodcock, sent a letter to the director of the Center for Tobacco Products, Mitch Zeller, directing the agency to engage in the rule-making process by, quote, promptly beginning to draft the proposed rule. There was no further elaboration on what promptly means, but given the fact that the agency received the citizen petition in 2013, as Desmond mentioned, and since then it has collected reams of information, it really shouldn't need a whole year to draft the rule. In theory, it should have a menthol rule almost ready to go. AATCLC and the other plaintiffs in the ongoing lawsuit that gave rise to the petition response also noted in a webinar they held last week that they plan to put their own pressure on the agency in the context of that lawsuit to get the rule out the door as soon as possible. So given the ongoing lawsuit, pressure from the FDA commissioner and public health groups, I personally hope that we see a proposed rule sooner than a year from now. And it probably wouldn't hurt for members of the public to put pressure on the agency as well by, for example, sending letters or emails or somehow just kind of sharing that the rule, it's important for the protection of countless lives and for public health to get the rule out the door sooner rather than later. Once a proposed rule is issued, what happens then? So the agency will put the proposed rule out for public comment, which is part of a regulatory process called notice and comment rulemaking. That process will allow for at least a 60-day comment period, possibly longer. And then during that time, members of the public, including you all, will be able to upload comments into the docket, which is available on the federal government's regulatory website, regulations.gov. We at the Public Health Law Center have a couple of publications available on our website about the commenting process and how to provide your input. And then when the rule is released for public comment, we'll also be sending out email notifications and have information about the commenting process and a link to the docket on our website as well. So you can keep up to date by visiting our FDA Action Center on our website. Once the comment period has closed, the agency will then go through all the public comments and determine whether or not they raise any important concerns that warrant making revisions to the rule. The agency will then release a final rule while also providing responses to the comments it received. And that process could take anywhere from several months to a couple of years. It really depends on the complexity of the issue and of the rule. In this instance, the rule itself isn't really the most complicated piece, but we know there's going to be an onslaught of comments from the industry and industry-sponsored groups. The Tobacco Control Act explicitly allows for the public to submit comments about what it calls countervailing effects, which could include the potential for illicit trade, as Mike mentioned. And we know that's something the industry is going to hammer on because it has in the past, including in its own comments on the 2013 citizen petition. While the data doesn't show that illicit trade is going to be an issue that would outweigh issuing the product standard, we can definitely expect to see a lot of information submitted about countervailing effects from the industry and the groups it funds. Once the final rule is issued, the Tobacco Control Act also states that the rule won't come into effect for at least a year after the date of publication, unless it's necessary for the protection of the public health to shorten that effective date of that time frame. Considering this is an instance where it would undeniably benefit public health to have an earlier effective date, particularly if robust cessation efforts are already underway, this is also something that could be addressed in public comments to the agency during the rulemaking process. And lastly, we know there's going to be litigation from the industry as soon as a rule is published. Not only is the tobacco industry extremely litigious, it has unfortunately been successful in its lawsuits in the past. So for example, it managed to knock down the FDA's graphic warning label rule in 2012, and then managed to hold off of the new version of the rule that was issued last year as well through litigation. So depending on how the litigation unfolds, it could take another several years to make its way through the court system, though ideally the FDA will be on strong enough footing that the rule wouldn't be put on hold pending the outcome of that process. So all in all, this is not going to be a quick process. While it would have been nice to see an actual proposed rule in response to the petition, or potentially a clearer time frame, the plaintiffs in the lawsuit, as well as all of us as members of the public, can continue to put pressure on the agency to move as quickly as possible to roll this out. And because the rulemaking process is such a slow process, I really do just want to highlight that these effort that the announcement, the FDA's announcement, and then sort of continued momentum on this issue really should serve to spur and motivate local efforts to enact local flavor bans. Not only do local governments, including state, local, and tribal governments, have the ability to move much more quickly than the federal government does, they can fill the gaps that are not covered by the agency's plans and prohibit the sale of all flavored commercial tobacco products. So with that, I think we're going to turn to some Q&A. I think we have a lot of questions coming in and we're happy to discuss them. So.
Yes, we have lots of questions already. Quite a few of them we expected. Go ahead and keep putting them in. We will hopefully get to as many as we can. And if we can't get to your question or you think of something in the future, definitely feel free to reach out. We are easy to contact. So first question, super important. Mike addressed it a little bit. We've heard from groups like the ACLU, but this question phrases it really well, I think. So we know law enforcement abuses their power to kill Black and brown people. So how will enforcement look? What will enforcement look like in the communities for people who continue to use menthol? Or what does enforcement of this rule look like? Natalie, do you want to take the first stab at that one?
Yes. So like Desmond mentioned, and Mike talked about a little bit too, is that the FDA indicated, and has always been true, that these regulations are enforced by the FDA and have only ever been enforced and only ever will be enforced against the manufacturing, distributing, and retail side of of the market, not the possession or use side. So the concern about individual targeting from the FDA is not apparent, and local police don't enforce these FDA regulations either. The FDA does. And so I think that what is important to note about this question is that this is really indicative of a very tried and true industry tactic, that they use misinformation and they misappropriate and manipulate something that is an extremely important issue and is a genuinely hurtful and, life important issue of police brutality, but they use that to spin their own message. And so that's the truth about what this would do and the impact of that on policing. But agreed that there needs to be an overhaul of policing in this country as well.
Absolutely. This isn't a new version of this problem. It existed before, it'll exist after. The other part of this that I think is worth mentioning specifically is, I've seen television interviews with people from the ACLU, and they are very quick to use the word criminalization. And I've seen their people say specifically, this will result in criminal penalties. And that's just not true at all. An FDA prohibition on menthol cigarettes would result in civil penalties for manufacturers and retailers who violate the law. So that's civil monetary penalties. The FDA does not put people in jail. They have limited criminal authority that they use very, very rarely. And in cases of, sort of extreme negligence by like food manufacturers, they don't kick down doors and put people in handcuffs. That's just not, this is the FDA, not the FBI.
One thing I want, if I may,
go ahead.
This just goes back to, what they're trying to do is play on the emotion of the moment that we're having post George Floyd in this country. And that what they're trying to do is despicable. And given their track record, I've expected nothing, no less from them. And as this moves on to rulemaking and comment period, I expect this kind of fear mongering to increase. So I think our partners and those attendees should be on the watch out for this kind of misinformation.
Right. I mean, there are a few legitimate reasons to argue that this shouldn't happen. And so the industry has to resort to things like this. You'll see other arguments like, what about illicit trade? And well, what about all the other stuff FDA should do? But none of those are arguments to not address this problem right now. They're arguments to address other problems as well. So, yeah.
And God knows this has been studied to death, right? This
Exactly. Exactly. Okay.
Desmond, a clarifying question is, sure. What about the situation of Eric Gardner where he was selling Lucy's? Can you just speak to that a little bit on the illicit trade side of things?
Yeah, I mean, so that's another case where those were local police officers and they were enforcing a local law. So again, this wasn't related to what the FDA does. So it's similarly like totally different world. Illicit trade, sort of does, there's an intersection of illicit trade and prohibiting products and, when you have sort of comprehensive regulation, but illicit trade looks very different when you're talking about a comprehensive action, like an FDA regulation. I mean, we all know there are, untaxed or low tax cigarettes that cross borders between states. And that's really a gray market rather than the black market. And because the FDA regulates manufacturers, there should be very little illicit trade when it comes to menthol cigarettes. We share a very long, very large border with Canada, and Canada has already prohibited menthol cigarettes. The FDA has authority over domestic manufacturers. And so the only way to bring illicit menthol cigarettes into the country would be through a port of entry, which are fairly tightly controlled, or across the southern border into Mexico, where there is a lot of drug smuggling. And I find it very hard to believe that smugglers who traffic in very valuable illicit drugs would bother with a product like menthol cigarettes, which comparatively is worth very little. So, it is something that the FDA should do. It has the authority to do what's called a track and trace program, where it would have a much more comprehensive control over products from the point of manufacture until they enter consumers' hands. But in any event, this is illicit trade is another thing where the industry says, what about this? What about this? And the truth is, even if there is some illicit trade, it pales in comparison to the health gains of a rule like this.
Yeah, and the FDA has considered the issue of illicit trade and found that actually there's very low probability that it will happen, right. Number one. And number two, police, like in the case of the Eric Garner tragedy, police will use pretextual stops or after the fact reasoning for why they violate somebody's civil rights. So this is by no means, it's a call for police reforms and not a reason to ban or to delay or stop the ban of menthol.
I think there's one more thing I wanted to say about this, and then I want to make sure we get to some of the other questions, is that there is genuine work to be done about penalties and the intersection of commercial tobacco regulations and penalties, and that's in state and local law. And their penalties, they're called PUP penalties. They're focused on youth, and they are penalties that have the possibility of increasing intersection between youth, and especially youth, BIPOC youth, and police. And so that has been one of the things that we have advocated for heavily. We've written about a lot, and we always suggest to any community that asks for us to help them with language to remove those penalties, because lo and behold, even though the industry has usurped this message in this convenient format, they were the ones that were lobbying for these penalties back in the 90s when all these laws were passed. And so just another reflection of willing to take any argument or use any means to line their pockets, essentially.
Right. So pup laws are purchase, use, and possession, which is why we call them pup.
Oh, sorry.
And no, that's okay. Acronyms. As Natalie said, they exist quite frequently in state and local law. The FDA has no authority over those three things. The FDA is specifically prohibited from regulating consumers. But like Natalie said, that it's definitely still an issue at the local level. We've been working for a long time of when communities are, revisiting some of their laws, like raising the minimum age to 21, to eliminate the pup penalties. Not only are they harmful, they also don't have any benefit. So it's kind of a no-brainer, especially if you care about things like health equity and social justice. So that's something to be aware of if you're advocating in your local communities. Back to, did you have one more thing to say?
Well, I was just going to say, can we start? We had a lot of questions about what products are covered. Can we start with that? And I'm happy to say it, or you can.
I want to go there next, and then I want to talk about the issue of what was petitioned for, what we got, a little bit of process, and then also there's a question about characterizing flavor, which I think is interesting as well. But let's talk about what products are covered, what we think is covered, what we know is covered, and what may or may not happen with some of the other flavored products. Who would love to start on that? Did you want to, Natalie? Or?
Yeah, I can. So our original petition was written in 2013, like Desmond said, which was before FDA even had authority over the newly deemed products that they deemed in 2016, which would be e-cigarettes, hookah, really anything that's made or derived from commercial tobacco besides cigarettes, smokeless, and roll your own tobacco. And so the original petition did petition for menthol to be removed from cigarettes. When the FDA sent their answer or their response, they said that that's what they were granting. And then I think, as Mike made clear, when they issued a press release about responding to the petition, they also indicated they were going to remove flavors from cigars, which is the remaining sort of combustible form of commercial tobacco. So that's what the FDA announced. And then they're going to go through this rulemaking process. So the rulemaking process is where they will actually propose this rule. And that will be an opportunity for public health groups to, if they haven't included other products or all flavors, to advocate for that as well as like a rule. And so we will see what the FDA actually proposes, but we'll assume that it's probably going to be removing menthol from cigarettes and removing all flavors from cigars. And that will be the limit of it. We can assume, but that doesn't mean that has to be the final rule.
Kyra, do you want to talk about e-cigarettes a little bit? We had a lot of people put that in their questions when they signed up for the webinar, and obviously it's front of mind for a lot of tobacco control folks. So do you want to talk about how this action would or wouldn't affect e-cigarettes and what we know and what happens next?
Sure. And I did just want to add to Natalie's comment right then to the public, the opportunity for public commenting is open to anyone. And so to the extent that you, especially if you have data, you have information, you work for a public health organization, or you just want to participate in the process, you can be a voice to advocate to expand the coverage of the rule. So just FYI. And so yeah, for the e-cigarette situation, so the proposal that FDA will announce is not going to include e-cigarettes, most likely. So the process for e-cigarettes and other deemed products that FDA determined deemed were within its regulatory authority in 2016, that process is going on simultaneously. It's the pre-market review process. Some of you may have heard of there was a deadline last September 9th of 2020 for companies to submit applications to the FDA to continue marketing those products. As long as they submitted an application by September 9th of last year, they are able to continue marketing their products until September 9th of this year, 2021. So the e-cigarette process is going on simultaneously, but it's different from this proposed rulemaking. That said, the issue of flavors is still very much present in that process. And it is possible that, throughout the commenting process on this rule, people could, raise the concern that many of the flavors that are in e-cigarettes, which includes menthol, are used by the same exact communities that, and that companies target the same exact communities that they've been targeting for years with menthol cigarettes. So I think they're related, but somewhat of like a Venn diagram when it comes to like how this is all operating. And I think it's probably a little bit more than we have time to delve into right now, and when it comes to like how that whole process unfolds. But you can check out some resources on our website. And I don't know if anyone else wants to add or clarify to what I just said.
No, I think it's probably good for this webinar. And we've done a couple of webinars on this, and we do have resources on it. And I'm positive that once we see the FDA starting to make decisions on e-cigarette marketing applications, we'll have more to say on that as well. So I do want to get to the other sort of related question, or there was multiple questions that sort of get to this issue of how exactly FDA will mechanically what a prohibition on menthol cigarettes looks like, and what about the cigarettes on the market that are not marketed as menthol, but they do in fact include menthol in them. So I will start, and then everybody else feel free to jump in if I miss something. So procedurally, we petitioned for the FDA to remove the exemption for menthol in the prohibition on characterizing flavors in cigarettes. And so in granting our petition, that's the least that the FDA could do. Now they can go much further, and then they've still been responsive to our petition, but they can do other things because they have lots of authority. So the proposal to address flavors in cigars, which by the way, we didn't include in our petition because we filed it before the FDA regulated cigars. So they probably would have said, you can't petition us to do this because we can't. So we didn't. Had we petitioned them at a time when they were regulating, we certainly would have said that that's an obvious loophole that needs to be closed. So lots of credit to the FDA and the FDA staff, who I know were pushing for that for a long time. It's a really smart way to be thinking about that policy. So we petitioned to deal with the characterizing flavor menthol cigarettes. We did, at the time of filing, also consider asking the FDA to just straight up ban menthol as an additive at any level. And after talking to a lot of folks in the scientific community, the decision was made to shoot for characterizing flavor because there was so much robust evidence, and there was a little less evidence on the impact of the sort of subliminal, was the word we used, levels of menthol on initiation and cessation. It just hadn't been studied nearly as much as it has now. But as I said, because the FDA went further on cigars, there is nothing to say that when the FDA proposes their rule on menthol cigarettes, what we'll see is that they have decided to eliminate menthol from all cigarettes. That's something that's well within their authority. There is plenty of evidence on it now. It's just not specifically what we asked for. So FDA's action, we know, will at least address the menthol flavored cigarettes where menthol is a characterizing flavor, but it could in fact go further and address menthol at all levels. I think that would be great. And maybe the fact that the FDA is thinking about cigars, maybe it is thinking about that as well. There was another sort of related procedural question about the fact that our petition may not actually be granted until there is a final rule. And that's true. we've specifically asked for something, and until we have that thing, the petition is not granted. But procedurally, what the FDA has done is tell us they are granting our petition, and they're beginning the process which implements the grant of the petition. And because there is litigation oversight over this process, I would be surprised if the plaintiffs in that litigation were going to, simply dismiss their case. I suspect they will hope that the court retains jurisdiction throughout the rulemaking process to ensure that the FDA follows through on what it said it would do. So that is where we expect things to go. Does anybody have anything to add on that? I feel like I was jumping around a little bit. I might have missed something. No additional thoughts? Okay. No. I saw one that I saw a question here that I wanted to. We talked about this for a minute, but there's a question about what the tobacco industry's response will be. And they will have lots of responses sort of all throughout the process. But let's start with the proposed rule when it comes out. I mean, you're already seeing their response, and their response is to get third-party groups to, raise issues like criminalization and illicit trade and things like that. Obviously, they'll comment in the FDA's formal process. What you are likely to see from the industry, and I think I've maybe already seen it in articles talking about this where they've interviewed someone from the industry, is the industry is going to say that menthol cigarettes are not more harmful than other cigarettes. And that's actually a telling admission, right? All cigarettes are so harmful that menthol cigarettes aren't worse. And what they will focus on is things like toxicity and carcinogenicity. And that may in fact be true, that if you smoke one menthol cigarette and one non-menthol cigarette, they have identical terrible impacts on human health. But that's not the test for FDA. So FDA uses something that Mike discussed, which is the public health standard. And there are 3 parts to that standard, and 2 of the parts are initiation and cessation. And we know that menthol has tremendous impacts on both of those things. Menthol makes it significantly easier to start smoking. It's why the industry adds it to cigarettes. And it also makes it harder for menthol smokers to quit, even though they quit at higher rates than non-menthol, or attempt to quit at higher rates than non-menthol smokers. So the industry's argument that they're not more harmful is irrelevant in this context, because the FDA regulates at the public health level, the aggregate level, not the individual level. And then, of course, I mean, we expect the FDA or the industry to file a lawsuit against the FDA once there's a final rule in place. Kyra, do you maybe want to, I'm putting you on the spot, do you maybe want to talk about what the industry would even use as a cause of action and how litigation could possibly play out, a challenge to the rule?
Sure. So like with the industry challenges to any other FDA rule, the industry is very likely going to file a lawsuit right after the final rule comes out. It will argue that the rule is what the law calls arbitrary and capricious. And for example, the FDA failed to consider important evidence, or it didn't comply with certain laws. So basically, it will push back on the rule and the evidence base for the rule, and any argument I'm sure will be raised, and then that will, with the graphic warning rule, for example, the industry actually sued 2 different groups sued in 2 different places. So there are likely going to be multiple lawsuits. They'll ask for the rule to be put on hold, and as I said earlier, hopefully that does not occur. So yeah, I mean, it's pretty much inevitable that it will happen.
Right.
Yeah.
One thing I wanted to mention regarding the issue that Desmond spoke about is what may surprise you, and what surprised me when I learned it was that the tobacco industry has always had a seat at the table. It has non-voting members on TPSAC. So all along it has been voicing its opposition. And it seems, if you read the response carefully, that the FDA was twisting itself into a pretzel regarding the issue of contraband. And actually, one of the reasons they offered for the delay was that they had to do even more research on contraband. And I believe that was to assuage, it's tobacco industry overlords. But I'll leave that there.
Yeah, no, I mean, I think that's very true. And the good thing is the FDA has to look at that public health standard, like I said, and it is required to sort of like examine things like illicit trade, but that's not the controlling measure of when it takes action. It's the public health impact. There are a couple of questions here. What?
Oh, yeah. Well, I was just going to suggest, can we more clearly, maybe we had lots and lots of questions asking our estimation of time, and at least a couple of people indicating that they don't understand what we were saying. So can we more clearly and succinctly say our best guess, maybe best case scenario and worst case scenario? Well, worst case scenario is like forever or not happening, but
yeah, no, that's a good one. So I mean, this is always tough because it's total speculation, right? But I mean, we can sort of walk through what a reasonable process might look like and how long it takes. I will say this could move a little bit quicker than, say an FDA initiated rule because there's litigation. But so typically, I mean, I think we expected to see a proposed rule fairly soon. It's sort of meaningless for the FDA to say, hey, we're going to do a thing, and then it not to happen for several months. But I will say nothing has been sent to the White House's Office of Management and Budget, which is sort of like the last step before a proposal is public, and it's sort of the first public step where something has happened. And rules can sit at OMB for months if there's something that the White House doesn't necessarily like, or there's a complicated proposal, or there's a lot of opposition, and things that sort of have sign off all the way up the chain, which this seems to have based on the fact that, the Secretary of HHS is out front on it. Those can sail through in, a matter of days. So we could see a proposed rule in the month of May. If it was more like the month of June, I don't think that would surprise me either. If we start getting into July or August, I think that the plaintiffs are probably going to raise the issue in the litigation. The proposed rule initiates a comment period. On a big rule like this, it's probably going to be, well, it's a big rule, but it's also one we want to get out the door quickly. So I would say either 60 or 90 days. There will definitely be requests to extend the comment period, which FDA often does. But if we have either a court order or a judge who might issue an order, then the FDA might not extend that. And then at the end of that, the FDA starts analyzing comments and developing the final rule. And that's often the period of time that is long. In this case, again, because there's litigation, one would hope that rather than being like a year or two, would be more like a year or less. 6 months, 9 months, 12 months, I think would be in the ballpark of reasonable. Reasonable in terms of like what the FDA would do, not in terms of like when I think they should do it, right? And then once there's a final rule, if the rule is formatted as a product standard, which we didn't really talk about, and it's probably a little bit of nuance to get into that's not necessary. But if it is a product standard, which it probably will be, the statute says that can't go into effect until a year after the final rule. But the FDA is allowed to shorten it if there is a sort of a public health imperative, which we think there is in this case. So at that point, 6 months would be not unreasonable. And then if you sort of assume the minute the final rule comes out, the FDA gets sued and things move quickly, and the rule isn't held up from being enforced by a court, then after that 6 months, we could have a rule that's enforced. So if you add up all those timelines, I think that gets us about 2 years from now. And I would say that is if everything lines up absolutely perfectly, you know, stars are in alignment and everything happens in the best case scenario. So I would say 2 years is like a reasonable best case scenario. But a more probably possible or likely would probably be more like 3 or 4. What were you going to say, Kyra?
Oh, I was just going to say, I mean, I think a few people were asking about cessation too, and like what's happening like while that process is unfolding. And I think maybe we should talk about that a little bit, because the response and the press release both talk about how the FDA is proposing to work with other entities, including, you know, state and other federal entities and tribal governments to ramp up cessation efforts. So I think that's one thing that maybe we should talk briefly about.
Yeah, for sure. Let's talk about that really quick, and then we're getting close to running out of time. And you know, maybe we'll have to do another one of these with just the volume of questions that we've got. But I want to talk about quitline cessation, and then really quickly wrap up with what should be happening at the state and local level now, and the potential impact of federal action in tribal lands as well.
1 second before you say that, Desmond, we did put together a short resource on this, and we're going to share that in the chat. I just want to make sure that we are promoting that. So maybe some of your questions will be answered there. Someone asked if we had a Q&A with all of these questions, and no, we didn't anticipate all of these questions, but just want to make sure that you know that there is a resource that you can look at and start with if you have questions.
Right, absolutely. And you know, when there is a proposal out there, we'll have tons of resources on that too. Like, we're not going to go away after this webinar. But cessation, quit lines, all of that stuff. Let's talk about that really quick. Does anybody want to jump in on that?
Yeah, so the FDA said that they are going to work with other agencies. I don't know if this is really like a change in policy. It shouldn't be. It should be that this is something they're coordinating all the time, right? But
I'm sorry, go ahead.
But they're going to coordinate with other federal agencies around the cessation, and to really focus on and think about culturally specific cessation efforts. And so I think that is something that is also worth saying. And someone asked about that specifically in the Q&A about what should localities do and what should states do, and anticipating and ramping up your messaging to be specific and sensitive to the communities you're trying to serve makes the most sense to me. And that's really good work. And we've seen that is really important and successful for example, in Minnesota, there's a specific quit line for those who identify as indigenous or members of tribes, and it's culturally tailored to them. And there's been a lot of success with that. And so that's really important. Mike, were you trying to say something? Sorry.
You covered it. Thank you.
And then Desmond, you want to say something about local work, or do you want me to go ahead and run with that?
No, go ahead. Go ahead.
So as I think it's pretty, like we've talked about pretty clearly, that the FDA is, you know, only committing to these combustible products, removing menthol from cigarettes and flavors from cigars. But as always happens, the FDA is leaving a lot on the table if they don't address all flavors in all commercial tobacco products. But that's a great opportunity for localities and states and tribes to adopt policy that would fill this gap, that would address the issue of not all products, not all flavors, and not all products. And also, as we recognize that this could take quite a bit of time, lives would be saved undoubtedly by localities and states adopting their own policies around these products. So there's that work has to keep going, and the FDA shouldn't detract from that. And one thing that might actually help, I suppose, is that the FDA does really focus on the health impacts and describes the health impacts. And so maybe using some of the information that the FDA did put out there and some of the language that they did put out there to articulate how important this is and how many lives can be saved might be something that helps those local advocacy efforts to pass more comprehensive laws.
Yeah, no, absolutely. I mean, we walked you through the best case scenario, right? So your city council could be voting on this in weeks, not years. You know, if you've already laid the groundwork and you're already thinking about it, right? The smaller your unit of government, the more nimble it is. And so you're going to get pushback from industry advocates that are going to say, well, the FDA has this under control. We don't need to do this at the local level. But like Natalie said, the FDA also put a lot of information out about how important this can be. And if you want to retain local control and protect your community, there's no reason to not do this at the local level. And then really quick, let's talk about whether or not prohibition on menthol cigarettes on the manufacture and sale would apply in tribal lands. We got that question specifically. Natalie, I'm assuming you want to take it, tribal law expert.
In general, the Tobacco Control Act and the regulations that the FDA has put out in the past have specifically contemplated tribes and has indicated that these regulations and laws are in effect on tribal lands. But as I was reading the illicit trade document again that the FDA put out a couple of years ago in connection with their ANPRMs, they sort of noted that it might be somewhat of an unresolved area, it's even to them, and something that has to be explored when the time comes. But in general, that's the general gist, is that they specifically contemplate tribal lands and reservations. And so generally it should apply, but it might be that there's still some gray area. There's always a gray area about this, but I think the more important point is that there's no reason for tribes to not exercise their sovereignty to implement really strong laws and to do just what we were talking about with localities and states, and I mentioned tribes too, but to fill these gaps, to protect their communities, to implement these laws themselves. And so that is an exercise of sovereignty to do that, and that's really important work. And we have folks, including me, who work on those issues at Public Health Law Center, and we're always happy to collaborate on those efforts.
Awesome, thanks. All right, I think we'll cut it off there. We're a little bit past the hour. I will say we will attempt to try to get resources out the door that answer a lot of the questions that you've raised that we haven't quite thought about. You're going to keep saying lots of resources for us on menthol. This is really exciting. We've been doing this for a long time. And pretty soon we're going to hit a point where all of you can be involved in the process too, and submitting your comments to the FDA to make sure they do the right thing. And we will have resources for how to do that as well. I'm sure we will be back with another webinar to walk you through the process. So as always, feel free to reach out in the meantime if you have questions, but thank you for attending today.
Thanks, everyone.